what can or can't a parent do unilaterally right before a divorce or even maybe after something is filed?
Well,
Hi, everyone. This is the Illinois Family Law Insider Podcast. My name is Katie VanDeusen, and I am the managing partner for Sterling Lawyers. And with me today, I have none other than senior partner Nina Kelly. Thanks for joining me today, Nina.
hi, Katie. Thanks for having me again.
Yes. So today we are going to delve into rights and what you retain or what you may lose when it comes to a divorce, specifically parenting time and decision making rights, and some strategic considerations that we need to really consider with Illinois divorce cases. So, specifically, we're going to be delving into what are kind of some initial rights that you have, and how can we consider whether or not you may lose rights to either a child or children throughout the pending case, and what strategic concerns we need to keep in mind when consulting or advising clients. So, the very first question we have, Nina, is what rights does a parent kind of automatically have, or what do they retain during the divorce process in Illinois when it comes to children?
So, until there's a temporary order entered, which will allocate like parenting time and decision making potentially, depending on the case, you have the same rights as before. Nothing changes. It doesn't like one parent gets to make decisions, the other one doesn't. You could just continue as really the status quo is typical, but really there's not really a right answer to this. It's kind of like, yeah, you're just still a parent as if you were still married because you are still married. However, that's for divorce actions. So if you are not married, the presumption, there are some nuances to this, but almost always the presumption is that the mom gets to say. And the dad needs to adjudicate himself as the father first and ascertain that he has rights. So that is the one very clear way that it's moms and dads are different in Illinois. So that's kind of the more important reason of why, in a parentage case, one parent does have a huge leg up, at least in the beginning of the case,
Yep.
where the end result obviously is to address all those things. But during the case, that kind of makes it difficult.
So, just to kind of recap for the listeners or the people watching. So, when it comes to a parentage case, which is different from a divorce, parentage is where two parties are engaged in maybe a relationship, but they're never married and they end up having kids together. So, in a parentage case, there is almost like an automatic presumption that mom, because it's biological mom, she kind of has all rights to the kid, and a dad would have to establish himself as a parent of that child in order to then take the next step of what do my rights look like, or what do I have rights to when it comes to this child. Whereas a divorce case, kind of both parents are on an equal playing field right from the jump, because this child is a child of the marriage. And as long as dad is listed on the birth certificate, I'm assuming, there's a presumption that that child is both of theirs. So mom and dad are kind of on that equal playing field. Is that what you're saying?
Correct. Yep, exactly.
So that's a really key, I think, difference that, depending on the case type, you really need to be considerate of when advising a client. And then what can or can't a parent do unilaterally in a divorce case? We're going to kind of focus on the divorce route here versus the paternity case. But, what can or can't a parent do unilaterally, right before a divorce or even maybe after something is filed?
Well, that's a good question because it's a total gray area. You can try to do whatever. It's just kind of more to do how the other person responds. So, a lot of people end up moving away from each other, or at least separating houses when something is filed. It's like, can I move away with the child? Yeah, some judges might have a problem with it, especially if you try to go more than like 25 miles from the other house. But if the other person's not going to try to stop you, you're not going to get, there's no law against it. So it really kind of depends how the other person reacts, similar to, signing your kid up for a different school or something like that. You can. It will then depend on how the other person reacts. And if they try to kind of use that as against you in the quote unquote custody battle, trying to frame you as somebody who's not trying to work together.
Right. Not facilitate kind of that co-parenting relationship or communication about the child, and kind of just unilaterally doing their own thing. So while there may not be like set rules established on the front end, do you feel like that could potentially have a strategic impact when, let's say, there's a guardian ad litem or even like a custody evaluator involved in the case, which is, further on down the line? But do you think that there are risks associated with kind of those unilateral actions?
There are, and I would say, if you're doing, if you're going to move with the child and you've been the primary caretaker and you're going to move to the town next door, close by, I don't think you're going to get knocked for that.
Right.
But if you're moving, again, more than 25 miles away, making it difficult for the parent to see the kids and they've been frequently part of their lives, something like that could come back and kind of show that you're not acting in their best interests.
Yeah, I feel like these situations are so fact specific. I don't know how you feel, Nina, in your practice, but I feel like it all depends. And I know that's such a lawyer answer, but I think
Right,
that that's actually accurate. It all depends on the
right,
facts of the case. What was the status quo during the marriage? Who was the primary parent? How involved have both parents been? And I think that then kind of funnels into how you advise a client when in this gray area, right? And like
right,
what the risk or exposure is, or if there is none. Um,
right.
and then
Totally.
when a parent is considering whether or not to move out of the marital residence and the timing of that, can someone technically lose rights if they move out of the marital residence before any type of court order is entered?
So you're not going to lose any rights necessarily. It's not like there's like an abandonment principle, which other states must have,
Yeah,
because so many people come to me and they're like, but I don't want to abandon. And I'm like, I don't know what you're
I
talking about.
know.
But so no, you're not going to lose rights, but I really advise against that unless there's like a really specific safety concern. I would say you can fine leave, but try to bring the kids with you. Just because judges and these guardians ad litem, excuse me, really way too heavily, in my opinion, rely on status quo. So what becomes a status quo, even if it's during the divorce, like, oh, well, it's working, let's just stick with it. Or like, what do you mean he needs, he only have every other weekend now. So why do you need more? It's like, that's only because I moved out. So really staying in the house to me is a really big priority unless you're taking the kids with you.
I agree. I agree wholeheartedly. I feel like, when it comes to this gray area where there isn't a court order entered, while technically both parents have, equal rights to the child, you don't have a court order. And without a court order, I feel like if there is a dispute or there is something that comes up, I think a lot of times too, when it comes to enforcement, you have nothing to enforce. And I think a lot of times too, I don't know, based on your experience, Nina, but I feel like police officers or law enforcement are going to be like, handle this in the domestic relations court. I'm not
Mhm.
touching this with a 10-foot pole. So when you get into these situations where like who should be with the child or where should the kids be without that court order, it really, can create problems, I think. So staying in the house until that court order is entered, securing time, I do think strategically is the best route, even though if you move out, there's no technical loss. It just, you don't have something to solidify and enforce in that instance if the other party's withholding.
Right. Which is a real risk.
Yeah. So let me ask you this, are there any strategic missteps or things that you would flag when it comes to like a loss of parenting time or a loss of influence?
Yeah, I mean, I would say a misstep is to not, if you do have a temporary parenting time schedule, to not exercise your time during the
Yes.
case.
Oh,
I mean, even missing like one session, people are like, well, you didn't even exercise the time that you had, which is so frustrating because divorces can take a while sometimes.
yeah.
That I would say, don't, coach the child and talk bad about the other parent to the
Yep.
child because that usually comes back. I don't know what any other ones that I'm missing are the main ones. I guess just posting on social media, huge no no.
Definitely. And I would say, like you alluded to before, moving out of the house without the kids and
Right.
kind of establishing the status quo that things are going fine without you. And almost having to dig yourself out of that new status quo that's been established
For sure. It's
versus,
hard.
yes, versus setting up yourself for success, and kind of still maintaining access to the kids and making sure that you are securing whatever time is best, you know?
Mhm.
And then what do you think in terms of like preserving a parent's involvement with their children? Is there anything that you would encourage a person to do to really kind of protect how much they've been involved when, let's say, they have an opposing party who is claiming that they're in fact the primary caretaker when in all reality it's been close to an equal, equal parenting obligations and kind of a share of parenting.
Kind of that's another like kind of annoying answer of like fact specific depends on like what the situation is. But going to doctor's appointments, documenting that you were there, making the doctor's appointments, and making saving communications. I like to get parties on parenting apps pretty early on in cases,
Love it.
just because it's easier to track what's happening. You can try to document what you're doing. I had clients document what days they are with the kid or provide proof. So it kind of depends on what the allegations are being thrown around, but proof and proof is usually what can help negate those claims.
Definitely. And show that you've been involved. I also think like, when you have a guardian ad litem or custody evaluator who like listens to the kids and is actively engaged with the investigation, a lot of times that comes out with what kids say too,
Right.
like especially most kids don't have a filter and they're going to know, who bathes them, who gives them snacks, who feeds them, who is there, when they're sick, who goes with them to those appointments. So like that also can come out just naturally. But I think to Nina's point, document. You've got to be able to show and provide some level of proof that you have been, an active, involved parent and what that looks like, or be able to describe it maybe during the, expert's investigation or the guardian ad litem's investigation too. Tell me a little bit, Nina, can you break down kind of the differences between what used to be called legal custody, which now is decision making, and then also parenting time, which used to be called visitation? What are the key differences that people should be aware of?
So they're completely unrelated, although the factors the court uses to allocate them are very similar. So usually, so decision making is what, again, what used to be called legal custody is the major decisions for the child, not what they're having for breakfast or what they're going to wear, but like education, healthcare, religious, and extracurricular activity decisions, who's making them. And typically it is joint. There's not technically, I don't think, a legal presumption of joint, but it is kind of a presumption of joint almost because it's harder to prove sole that it's in their best interest.
Absolutely.
Um, but you can get sole. Sole, I have a lot of clients come to me. I don't know about you, Katie, but they're like, I want sole custody. It's like that is not a phrase in Illinois. And you're not, you can get sole decision making. That is hard, but it's not impossible. You are not getting 100% of the parenting time. I've never done it. I've never seen it. I know it can happen if one parent is like in prison or like
Or like not involved or doesn't care.
right.
I've had reservations of
Correct.
parenting.
I've had reservations of parenting time, meaning that, but like they can always come back.
Right.
But not getting any parenting time is almost, I mean, it's nearly impossible but there can be restrictions, right? Supervision or just a couple hours or just phone calls or whatever. So I think that's the biggest distinction is they are completely separate things. And one parent could just see the kid, 1 week a year and have joint decision making.
Right.
Maybe if they live really far away and they're still involved. So
Right.
they are just very distinct things, which I think people get like they get muddled together when really they shouldn't be.
Correct. I think one other thing to note, or maybe two. So I think to your point, Nina, the other thing that I've always encountered is like, no matter what, even if you do have sole decision making, you still have to communicate with the
Mhm.
other parent. That information sharing is, I think, standardized across all cases and almost like a base level expectation among parents where no matter what the court decides in terms of decision making and parenting time, or even like residential placement, that information sharing and access to information is like a base level right, no matter what.
Mhm.
And I think that's always going to be in existence. So that's like the other follow up I would have. And then the other thing too is, this like primary parent designation and this kind of like residential placement. Like, I think that's another kind of nuance that is tied to parenting time, but also is still a little bit different almost from decision making. So, can you describe a little bit about residential parent or residential placement, and how that comes into play with like school registration.
So yeah, so technically, usually wherever the child is for more than, if you look at like a school district website, for example, I think usually it's probably like, okay, wherever the child is for more than 50% of the school nights or something like that would probably be
Yep.
what it would say. But in your custody or parenting plan or allocation judgment, you can actually dictate who's going to be the residential parent for school purposes, which has to be in your parenting plan. But it doesn't mean anything other than that. Like just because you are, residential for school gives you no other rights
Yep.
or anything. There is no such thing as primary physical custody. It just comes down to the parenting time schedule. And the parenting time schedule does, if you're a majority, have child support implications, but it does has no legal right implications other than where they're going to be enrolled in school, which again is something that I think is just hard for people to wrap their heads around because it's so different than what it used to be.
Totally agree. And then in your experience, Nina, is there any kind of default rule that exists that, people should be aware of when it comes to divorce cases, and kids?
What do you mean as far as like things to avoid?
I mean, like in terms of like, where's the default that exists? What's the presumption that exists, in a divorce case where there are children? Is it that both parents do in fact have equal access and equal rights to the children, or is there, a different type of presumption there?
Oh, I see what you're saying. No, as far as access and everything, I mean, it's pretty much going to be yes. Both parents are going to have access. Both parents are going to be, allowed to communicate, exercise time. It's more just like a spectrum of if how much time.
Yep.
But then you can put restrictions on things, but that would be kind of like your burden to prove that the parent should have a restriction.
Absolutely. I totally agree. And then, just to reiterate to everyone listening, just because you move out does not necessarily mean you lose rights. However, it could have an impact overall on the case as a whole when it comes to the outcome, right? Or a new status quo that's been established where you're not really actively involved with caretaking, or you have, severely limited parenting time that kind of
Right.
is being dictated by the other parent. And then, Nina, in terms of like unilaterally withholding kids, what's been your experience when it comes to a parent who, let's say there's no safety concern and they're just withholding the child from another parent who wants to see the children?
So I guess it depends. If there's a court order in place, then no, don't do it. You're going to get contempt findings against you. You could lose the child for more of the time. It's a
Yep.
big no no. You could be on the hook for attorney's fees, a bunch of things. But if there's no court order in place, I almost hate to say this, but like before once a case starts, there's no court order in place, people very, very rarely get penalized for withholding the child. It's just kind of the way it is because the court doesn't know what's going on yet. The attorney's going to say argue all they want, but until they get a neutral like the GAL involved, nobody's going to listen to just saying, okay, well, I want the child back because the judge is like, well, I don't know what's been this. I don't know what's normal. What should it be? I will say the one consolation people can have if someone is withholding the child is that you can get a temporary schedule put in place and it might take a little bit of time, but once there is one, there will be a court order. But B is yes, once there's a professional involved, like the guardian or the evaluator or something, or in the event of a trial, you can say, look what they did when there was no court order. They're not going to facilitate a relationship between me and the child, which is one of the factors the court has to consider.
Yep.
They're not going to co-parent and communicate effectively. So that's kind of one way you can try to use it against them, but it's not doesn't necessarily hurt them as much as it should.
So true.
Yeah.
Um, and then in terms of wrapping up, Nina, and kind of some closing thoughts, what would you say is the number one thing that parents should never do or should not do if they want to stay and active and involved, if they want to be active and involved in their children's lives during the divorce process?
And I would just say don't just like neglect to make an effort. Like again, try not to move out. If you do move out, still come get them try to see them as much as you can. Do the doctor's appointments. Like you just have to don't just check out and say okay, well it'll be handled in the eventual divorce because it's like then the eventual divorce is going to have an order that you don't like.
Exactly. Yep. Thanks so much, Nina, for just taking the time to kind of share your thoughts and your experiences and kind of talking through rights when it comes to parenting time and decision making in divorce cases, and also just helping people in terms of strategy and what to do in these circumstances. So, thanks for joining me today.
Yeah, thanks for having me. Bye, Katie.
Thanks. Bye, Nina.
Navigating parenting time during a divorce is only part of the equation. Once a custody evaluator gets involved, the stakes get higher. These professionals can carry serious influence in court, and too often, parents walk into evaluations unprepared for what's actually being assessed. Well, in this next video, we break down what evaluators look for and how the recommendations shape outcomes and the missteps that can quietly damage your case without you realizing it. Watch now to avoid being blindsided.